Dear students, in this video, we will learn about Workmen's Compensation Act. The purpose of the Workmen's Compensation Act 1923 is to provide adequate protection and social security to the workers. It is one of the earliest measures adopted to benefit the laborers. It provides the knowledge about how to compensate a workman handicapped by an injury from accident. If personal injury is caused to a workman by accident arising out of and in the course of employment, his employer shall be liable to pay compensation. If a person employed in certain occupations are liable to be attacked by certain diseases, the employer will be held liable to pay compensation. A personal injury is not necessarily confined to physical or bodily injury. It also includes psychological injury such as nervous shock, insanity, etc. The Act imposes legal obligation on the employers to pay compensation to workmen involved in accidents while working in the premises. The Act also provides the appropriate definition to terms such as dependent, employer, partial disablement, total disablement, wages, and workmen. Workmen's Compensation Act has been amended on 9th January 2010, is now renamed as the Employees' Compensation Amendment Act 2010. After 2010 amendment, the minimum compensation payable on death from the injury is increased to Rs 1,20,000 from 80,000 or 50% of the monthly wages of deceased multiplied by the relevant factor. The minimum compensation payable on permanent total disablement from the injury is increased to Rs 1,40,000 from 90,000 or 60% of the monthly wages of deceased multiplied by the relevant factor. This Act does not apply to factories covered by the Employee State Insurance Act. The Act also provides that in certain cases of injury, no compensation is payable. For example, any injury which does not result in the total or partial disablement of the workman for a period exceeding 3 days. In certain cases, employer is not liable to pay compensation. Such cases are: number 1, when the accident did not arise out of or in the course of the employment. Number 2, when the workman filed a suit for damages in the civil court. And number 3, when disablement lasted 3 days or less. This Act also lays down the rules regarding the distribution of compensation. If any question arises in any proceedings under this Act, no civil court shall have jurisdiction to settle, decide, or deal with any question which is dealt with by a commissioner. Under this Act, the compensation shall be paid as early as possible. In contravention of any of the provisions of the Act or rules, an order in writing made thereunder, the Act prescribed penalty which includes fine up to Rs 5,000. Let's look at some of the landmark judgments which helped us to interpret the Act appropriately. In case of Central Glass Industries versus Abdul Hussain, the Calcutta High Court in 1948 held that arising out of the course of employment does not mean that personal injury must have resulted from the mere nature of employment, and is also not limited to cases where the personal injury is referable to the duties which the workman has to discharge. Similarly, in case of Janki Amal versus Divisional Engineer Highway, Kozhikode, the Madras High Court in 1956 held that the employee must show that he was at the time of injury engaged in the employer's business or in furthering that business and was not doing something for his own benefit or accommodation. Thus, dear students, we learnt about the Workmen's Compensation Act 1923 and its provisions. We also covered some of the landmark judgments associated with this Act. Trust you will find the information useful.